Our first speaker is Professor Lorraine Weinrib. She is from the Faculty of Law at the University of Toronto. Before joining the Faculty of Law in the Department of Political Science there in 1988, she worked at the Crown Law Office, Civil Ministry of the Attorney General in Ontario, holding the position of Deputy Director of Constitutional Law and Policy. Her work included legal advice and policy development on constitutional issues and extensive litigation, frequently in the Supreme Court of Canada. Our topic is transnational jurisprudence. Please help me welcome Professor Weinrib.
It's an enormous pleasure to be here. I commend the organizers for the brilliant idea of holding this conference in honor of President Barack. And I also thank them very much for bringing together so many people with whom I have warm collegial relationships, and I welcome the opportunity to have new friendships at this law school. I chose a challenging topic, what is transnational law, because as a Canadian and a comparativist, I find the debate in the United States and the extreme positions in the debate fascinating. This is quite a unique reaction to what is a trend that is developing in the world, and I wanted to explore it in this paper. So what is transnational law? The title of my presentation brings into focus two interrelated phenomena that have electrified U.S. constitutional law and theory, judges, academics, and politicians in recent years. The first is the globalization of constitutional law since the Second World War. Constitutional forms have replicated themselves not only in new national states and failed states, but also in regional supranational configurations, all including rights protection with judicial review. The second related phenomenon is the penetration of international law and its norms, especially rights norms and humanitarian strictures, into national systems of public law. While the U.S. debate on transnational law is a rather recent preoccupation, both of these phenomena are not new, and they have not been absent from the United States in the past, and they are not controversial in other countries. By that I mean other liberal rights-protecting democracies. As a Canadian and a comparativist, I'm perplexed. What is this debate about? Why is it raging singularly in the United States, where we all know the basic model of written constitutions with rights, protection, and judicial review arose? And more importantly, how do we evaluate the opposing arguments as to the legitimacy of judges invoking, referring to, even to reject transnational law? First, I turn to the question, what is the debate about? Since the end of the Second World War in nation-states around the world, national constitutions have come under the strong influence of foreign constitutional law as well as international human rights norms. Let me refer first to new democratic constitutional texts. The transnational engagement informs the creation of the text in terms of substantive values and also in terms of institutional roles, and also enters into the interpretation of these texts, the hotly contested issue in America. And in addition, American experts have been heavily involved in the formulation of the texts of these non-constitutional rights protecting instruments. And whenever I go on the international circuit and I'm asked to share my expertise in the Canadian Constitution as a contribution to new constitutional drafting, I am told that the Canadian approach is much more gentle than the approach of American constitutional experts fulfilling the same role. The Americans, these people in these other countries forging their constitutional futures, tell me, prescribe that it's appropriate for other countries and wise and natural for them to adopt American substance and American preoccupations and controversies and American approaches to interpretation, while Canadians like myself come in and say, well, this is what we did, and this is why we did it, and this is what we think is successful, and this is what's problematic. And so the American stance seems to clearly be that export is okay, but import is not. And that's a curious position. The controversy about interpretation according to transnational norms applies more to old constitutions than to new ones. Now, in many instances, without constitutional change, and only with tumultuous historical events, either on the world stage or in a particular national constitutional setting, countries have, their courts, politicians, the public, have opened themselves up to the influence of transnational law in respect to old constitutions. And this has been the case even when there is strong contrast in the constitutional cultures, history, and social, political, and economic contexts. So this is a very interesting phenomenon, but it is a phenomenon that takes place in many places. It's in the United States where there has been very, very strong opposition to this pattern. To complete the picture, I note that constitutional law and international norms also enter into the formation, interpretation, and development of regional and supranational systems of rights protection, like the European Convention on Human Rights. Now, how do these transnational considerations actually enter into adjudication? Well, sometimes it's a bottom-up dynamic, and sometimes it's a top-down dynamic. So let me turn first to the top-down. The judges themselves may introduce these considerations, and there are a number of accounts of why this happens. And one that's very interesting is this has to do with new opportunities for judges all around the world to meet together in various fora, sometimes academic, sometimes for judges only, and to discuss adjudication and to look at borrowing between national systems and bringing in international human rights norms. Now, there's always a question as to why these events are taking place, but one of the presuppositions of this happening is that judges have something to talk about with each other, that there's some common project, and I suggest that it is the rights protecting project, which in America is considered to be quite national, quite historically rooted, but elsewhere is considered to be a common modern project, which comes out of the repudiation of Nazism and communism, etc. Sometimes the entry into adjudication is a bottom-up process where parties to rights cases, interveners or amicus curiae, bring in submissions. Sometimes they're invited in or permitted to enter the case in order to bring in new perspectives, which include the transnational perspectives. And sometimes, and this is a development which I found quite surprising when I started to notice it, that interveners and amicus curiae, at least in Canada, can be themselves transnational NGOs or even national or supranational political entities which become concerned with local law, local constitutional law, and participate in the proceedings and bring in their expertise from outside the country. Now, one of the elements in the debate in the United States that I find odd is that the position of the people who oppose transnational law often takes the argument far beyond anything that's actually happening in the Supreme Court, even though they pin their commentary on the cases in the Supreme Court. What the Supreme Court of the United States has done in this handful of very interesting cases is very mild and temperate reference there is no suggestion in these cases, for example, that there's something binding or even presumptively binding in bringing in this transnational material. On the contrary, it's often brought in to reject it. But the opponents often say that it is being brought in as authority, or with, as creating a strong presumption that then has to be dislodged, and so that the American national and American historical and American democratic understanding of the American legal system is being assaulted in some way. So one of these odd characteristics is taking the argument too far, also taking the argument beyond what I think is fair in terms of the actual cases, to say that the judges are selecting the countries they're using, or are selecting the countries that have produced certain results in order to weight their own political or personal preferences. There's no sign of that, really. The examples that are in play are examples where there is an overwhelming trend being observed, or a preponderance of opinion in national and supranational rights protecting systems. And so there's something going on that is not irrational or result-oriented choosing, but the allegation is that that is what is happening. And the critics then say, well, we can find other countries and that do otherwise, or we can find lots of examples where rights protection is actually stronger in the United States than elsewhere, and so the transnational engagement will actually reduce rights protection in the United States. But all of these arguments are overheated and exaggerations of what has actually happened so far, because the examples of court decisions or of constitutional text that have been taken by the Supreme Court judges who favor using this material are examples that come from modern liberal rights protecting countries. And if they had chosen other states to look at in this context, they would have been looking at states that I think all judges in the Supreme Court of Canada, sorry, in the Supreme Court of the United States would think it would be shameful to put forward as exemplars of rights protection. So how are the particular countries selected, or the particular constitutional rights protecting systems? First of all, it's clear that the judges who are using this methodology are looking for similar constitutional text or guarantees, or application of common methodological approaches. This seems to be a much more defensible use of transnational law. Very often the judges are using it to confirm a result that they have already come to on traditional American methodological approaches. The cases that are in play are all cases about rights protection, but more particularly, there are cases where the rights claim is often brought forward by a traditionally marginalized group, and there are often arguments that are made against laws that are long established and deeply rooted in American culture, but they are also characteristically laden with moral values. And so the question of what exactly is being assaulted in the American legal ethos is very interesting when those are the cases that are sparking the constitutional debate. It is often said that foreign law, comparative law, begins as a window into an exotic, unknown system, but if the comparative engagement is pursued, transforms itself over time from being a window into the other system with the very high learning curve that's usually involved to become a mirror, so that one is actually seeing more about one's own system than one understood before. Now, you may think this is fanciful, but when I teach comparative constitutional law, and I'm happy to say President Barack often participates in the classes that I teach. What often occurs about halfway or a little bit further into the course is students come up to me and kind of whisper, as if they've sort of discovered something very special, that even though they are studying the constitutional systems of Israel and Germany, that what they are really learning about is the Canadian system, that they understand so much more deeply certain characteristic features or choices or oddities about the Canadian system that they didn't understand before, and also that they're aware of features in the system that they didn't understand were important before. And so the comparative engagement often ends up being just a platform for more deeply understanding one's own system. And so against all of these considerations, I have to repeat the question, why is this so controversial in the United States? Let me take just a moment to reflect on the Canadian situation. I participated in the political discussions, the drafting, and a number of very highly contentious constitutional cases that led up to the adoption of Canada's Bill of Rights in 1982. Now, the Charter, and this is no exaggeration, in 1982, please remember that date, brought the Enlightenment to Canada. This may seem like a strange claim, but in fact, the very heavy initial litigation had as its result, not its purpose, the invalidation of many, many of these deep-rooted public policies, many of which we had inherited from Great Britain, from the colonial period, that were steeped in faith-based commitments and that viewed the nation as homogeneous in terms of race, that privileged men over women, that didn't have much time to think about children's rights, and that created quasi-establishment in terms of religion, race, ethnicity, etc. And we hadn't even gotten to questions of the new charter guarantees of disability, of protection against discrimination on the basis of disability or age or some of the other novel features of the Charter. So the Charter brought the Enlightenment to Canada, the idea that people are free and equal and that they have full political rights to participate in the political system, and that the state has the duty not only to leave them alone but also to support their individuality and their equality. What was interesting about the drafting of the Charter is that it was a fairly comparative engagement. The most contentious issues were not the substantive protections, because the Charter was designed to fulfill Canada's international obligations in terms of human rights protection, but the institutional roles were very, very contentious. And this is why I can understand that the question of what it is that judges should be doing, how much discretion they should have, and whether they have to be tied down to doctrines like originalism to constrain discretion are very, very important. What happened in Canada was that the final resolution, without which the Charter would not have been adopted, was an institutional resolution, which is somewhat distinctive at the time. First of all, there was the adoption of a methodology, which is already becoming quite prevalent in the world, to engage in rights protection analysis in the courts on a two-stage system. First, purposive interpretation of the rights, which was mentioned this morning in terms of President Barack's methodology, and purposive interpretation of the rights, as I understand most countries do it, has no national, nation-based, morality-laden historical understanding. Purposive interpretation is something that judges from all over the world who use this interpretation can use and learn from each other about, because it is not distinctive to any particular nationality, and it transfers quite easily into the supranational rights protecting instruments as well. So purposive interpretation of rights is the first stage, and then we have what you would call balancing and strict scrutiny, intermediate and rational basis scrutiny, but proportionality is a little bit more systematic. I hope it's not offensive to quote from students of mine who, taking an American constitutional law course that I used to teach in Canada a few years ago, year after year, would often say when we got to reading the American cases carefully, I don't quite understand what they're doing here. I don't understand the methodology because they don't separate the first stage from the second stage, which I'm going to describe, and one can't tell from reading the arguments who has the onus of persuasion and supporting the argument. And then the students would always use the same word. I think I taught this course for 3 or 4 years. They would say what the American cases are quote unquote primitive because they do not structure the second stage carefully enough. So I hope I have piqued your interest enough that I can now say something that's quite technical. The proportionality analysis in the second part of the rights analysis is a sequence set of arguments that provide the judges with a framework which can, and I think in most cases does, preclude the possibility of the judges engaging in political or personal self-indulgence and result-oriented decisions. So, just to make this as shocking as I can, this is a procedure of a set of methodological steps in which law is considered to be separate from politics. So the first stage is a legality stage. Has the impugned provision or state action been prescribed by law? So before the state can defend a purported breach of a right, it has to show that it has actually created the encroaching law or policy in the form of law. So is it legislated? Is it subordinate legislation? Is it an administrative decision under a legal rule? And the next set of tests are quite similar to what you do in your balancing process, but they're systematic, and the government bears the onus of persuasion and factual record, if there is any. Okay, so the first is that the purpose of the law has to be formulated, and then the actual law must forward the purpose of the law, so a rational basis, but then there's more. You don't end with rational basis, and then the measure must encroach on the right as little as possible, minimal impairment, least restrictive alternative, or other formulations, but you have to do both, rational basis and minimal impairment. And then the last provision is more of a balancing type provision, but in my view, it is a balancing examination that does not go beyond the ideas that pertain to rights protection. Now that's a fairly narrow view of how the last stage works, and President Barack is writing a book on that at this time, and it is a theoretical book and a comparative book, and so it will give much more information about what is happening all over the world in terms of all of these stages, but particularly this very complex last stage. Okay, why do I go through that detail? Well, the point is that this is a mode of analysis of rights claims that is just permeating the world, literally. It's seen everywhere. And it is the way that modern constitutional rights protecting systems protect against what is, I think, the main concern of the American judges, academic lawyers, and politicians who object to transnational engagement because it does constrain discretion. Some kinds of arguments are simply off the table because they are not appropriate to the rights universe of considerations. And for the arguments that remain, the government can make the argument that, but then this methodology requires the government to bring whatever is necessary to support the argumentation. You can't just make the argument and not support it. And sometimes that requires real evidence. Sometimes it requires social science. Sometimes it requires some kind of special expertise. Sometimes it requires some sort of statistical information. So the arguments on of the opponents of this transnational engagement, I think, are a bit overheated, and I think that they are overheated in some different ways. They are not actually reacting to what the Supreme Court judges in the controversial cases have actually done, number one. And number two, they're not sensitive to the fact that the foreign material that's being looked at has actually gone through the prism of this very elaborate institutional structure with all the methodology that I've mentioned, which is designed to, and I think usually successful in, precluding political and personal result-oriented work by judges. Now, I move from the opponents' positions to those who would defend the use of transnational material. And here the debate, again, becomes curiouser and curiouser, because a lot of the published material, not on the court so much, but in the academic literature and by the judges in speeches and debates, is quite utilitarian. There are the invocations are invocations of usefulness, of stature on the world stage, of problem solving. So there's a lot of fire and storm on the opponents' side, because they're invoking American heritage and history and the framers and democracy and separation of powers. And on the other side, you have these very practical considerations. I'm very, very curious as to why the debate is so lopsided. Now, I want to just mention some of the other characterizations of the academic debate that are not as substantive as the comments that I've made, but give an impression of where the debate could be put on a more intelligible and rational footing. The first thing is there seem to be at least 3 streams to the debate, and why I haven't done all of the charts and systematic work that I would prefer to delegate to a student on this. It seems that these 3 streams don't footnote each other. So each stream is talking to itself, so to speak, but for a real deep engagement as to what the weight of arguments are for and against the engagement in transnational material, these streams have to start talking to each other. So the first stream is a stream created by American constitutional specialists. By definition, they're not comparativists, or not real comparativists, because they haven't actually studied other systems, and they don't read other judgments, and it's an incredible learning curve. So I'm not being critical when I say that, I'm just being descriptive. And so what they're doing is they're like fish swimming around in an aquarium when there's a whole ocean out there. They are looking at everything through American categories, and I think that American categories simply can't solve the question of whether the American legal system should open itself up to transnational law. The second stream are sometimes American academics or academics from Europe or South Africa or wherever who are publishing in American journals or participating in conferences and writing in collections of the essays that are produced. They bring enormous expertise. Sometimes they know American constitutional law very well, but they're speaking to themselves again, if anyone at all, and they enrich the debate enormously, but they're off in a part of the literature where it seems no one else is reading them. The third is the incredibly helpful contributions by judges of other courts of constitutional jurisdiction in other countries or in the regional or supranational rights protecting courts. And they bring in their accounts of what their courts do with transnational material. So this is firsthand very sophisticated material by very sophisticated adjudicators in rights-protecting systems that have different histories, and sometimes they're civil law instead of common law, and sometimes they're new and sometimes they're old, but it's very, very valuable material. And again, this doesn't seem to be footnoted and moving into the general discussions. And I think that that is something that is an odd characteristic of the debate, but also a characteristic that diminishes the quality of the debate. All right, let's see how I'm doing for time. Pardon? Okay, so let me just take a couple of moments to conclude. The arguments against the incorporation of transnational law, as I see it, are arguments that are arguments about the nature of law, not transnational law, but the nature of law, and therefore the nature of constitutional law in the United States. So these are very, very deeply held, important ideas. What it boils down to is the idea that when there is a constitutional text, to protect it against this discretion, unbounded discretion of judges, it has to be tied to the history of the text. The progression of the originalist argument is taking, and it isn't stable, and I think that's very significant. The progression of the originalist arguments to protect against discretion, which we talked about earlier today, is a progression that is step by step by step, emptying the whole process from any normativity. And the Heller case is an amazing example, and there's tremendously interesting academic work being done on the history of originalism and the Heller case itself in the academic literature. That's another body of literature that should come into this transnational debate, because originalism is the core of the response to discretion, and discretion seems to be the whole problem that the transnational opponents are putting forward. The purposes of the originalism approach to avoid activism and subjectivism and lawlessness, etc., comes at a very high cost because of this emptying out of normativity, and also emptying out the whole engagement from any connection with the modern world. I must say, I can't believe that this is what the founders had in mind. They were revolutionaries, they were children of the Enlightenment. I don't quite understand this. But if there are other ways of curbing discretion, then perhaps they should be looked at. And what one sees in this post-war development and the methodology that I've mentioned is that there's a whole delineation of what it is to have a constitutional Bill of Rights, which is interpreted with strong connection to the modern world, strong connection to the social reality of people who are seeking rights protection, with awareness that democracy isn't enough, and that there are many people whose liberty and equality will never be protected fully by democracy. There must be some other way of dealing with the aspiration to respect everyone in terms of their freedom and equality. And in fact, within this alternative living constitutional model that is thriving elsewhere, there is the understanding that democracy is not legitimate unless everyone is protected by rights actively by courts that scrutinize public policy developed on a majoritarian grid for fidelity to the freedom and equality of every person. Let me say that a little bit more simply. Being an occasional voter is not enough in the modern pluralist multicultural world of liberal democracy. What one has to have is real-time, full-time protection of rights. That means judicial review. It means a lot of judicial review when one moves into the system. But then, magically, if it works well, the political actors, the government officials, everyone who exercises public authority internalizes the substantive values and internalizes the methodology by which fidelity to the substantive values are realized, and the courts can then have a lesser and lesser role. The legislatures do the rights-protecting job on their own, and one has what is called rights-based democracy. Not lawlessness, not judges making it all up, and not the caricature of a living constitution that is put forward by the opponents of transnational law. Thank you.